and 57 of the judgment of the High Court. At that paragraph, you'll discover that the judges were inspired by a decision called Commission for the Implementation of the Constitution versus the National Assembly of Kenya and 2 others. 2013 EKLR. I would invite you, my lords, to fish that judgment and read it yourselves for its persuasive value, and you will discover the following things. 1, the judge in that matter, Lord Justice Lenaola, now Judge of the Supreme Court of Kenya, was invited to find that the Constitution of Kenya has a basic structure, and he so found. He was invited to make that finding by Senior Counsel George Oraro, currently appearing for the Attorney General in this matter. He was invited to make that finding by the very learned counsel, Mr. Nyamodi, currently appearing for the Attorney General in this matter. I want to just cross-refer to the submissions by the very learned Senior Counsel, John Haminwa, as to whether people exactly spoke what they believed in when they took this podium. But we'll make that finding. At the end of it all, we'll invite you to find that indeed it is true that Kenya's unique history, Kenya's constitutional text, and Kenya's constitutional context has a basic structure. The second question, my lords, that I would invite you to have a conversation with your clerks in chambers when you retire from this heavy duty is to ask, what exactly was the obligation of the High Court judges, and did they discharge that obligation in accordance with the prescribed rules or principles? The judges of the High Court, so far as the case of the 74th and 75th respondents are concerned, were invited to interpret the Constitution and to enforce rights. When judges are called upon to do that task, they exercise a jurisdiction that is prescribed in this Constitution and whose parameters is also supplied by the Constitution. For example, when they were called to enforce rights, they were subject to Article 20 of the Constitution that informed them that every person shall enjoy rights and fundamental freedoms to the greatest extent consistent with the nature of the rights and fundamental freedom, to the greatest extent. When the judges therefore say that we must secure citizen participation through first citizen information, civic information first, civic education as part of primary constituent power, constituent assembly, then you move on to the third stage, then you go to the referendum. Does that secure least enjoyment of rights, or does that ensure greatest enjoyment of rights? I submit, to the extent that inevitably you will find that that ensures maximum enjoyment of citizen participation, you must reach the inevitable conclusion that the judges had the correct approaches to the resolution of the dispute that was before them. The judges were then also obligated to utilize the guidance in Article 259 of the Constitution. Article 259 of the Constitution has a catalogue of many principles which in scholarly terms are summarized as a purposive approach to the interpretation of the Constitution. Once you read each of those elements in that catalogue, they are what we call a purposive approach to this Constitution. In applying the purposive approach, the judges delineated 3 powers that can be found in this constitution: primary constituent power, secondary constituent power, and constituted power. The question I'll be asking is, isn't it true that if you read this constitution, you act those 3 powers? Article 1 yields such an interpretation. So you cannot fault the judge for the interpretation approach that they adopted in their resolution of this dispute. Allow me, before I deal very briefly with the direct question of the delimitation, distribution, and creation of constituencies, which bothered those 2 litigants now before you, to respond to some questions that my lords did raise yesterday. I think it was my Lord Justice Tuyot, you'll pardon me if I'm wrong, who asked a colleague of mine, learned counsel, the question whether in discovering amendment is the same thing as a repeal. In reference to the Constitution, one can take recourse to the Interpretation and General Provisions Act. Thank you so much, my Lord. Our direct and straightforward answer to that question is that Section 2 of the Interpretations and General Provisions Act expressly prohibits you from taking recourse to that statute while interpreting the Constitution. It acknowledges that that statute has a definition of amendment in reference to statutes. But when it comes to the Constitution, it expressly bars you from using that one. That is an acknowledgement of what the respondents have been telling you here all along.
Sorry, Mr. Ngoya, that's important.
Yes, my Lord.
You are saying that it expressly bars you from using that method to the Constitution? What is the wording of the statute?
The wording of, allow me just to put it this way, Section 2 of the Interpretations and General Provisions Act expressly says that that statute does not apply to the interpretation of the Constitution.
Does it say so in those words?
I need to...
That it doesn't apply to the Constitution? I mean, I just want to know that.
Yes, it says so in those expressed words. In fact, it says, for purposes of that statute, the Constitution is not written law. It says so expressly.
Okay.
Thank you so much, my Lord.
That's Section 2?
Section 2 of the Interpretations and General Provisions Act.
Thank you.
Thank you, my Lord. Having said that, there was a question raised by, I think, my Lord Justice Kiage on the question of burden of proof, where a litigant comes to court and says there was no public participation. In fact, learned counsel stood here and audaciously told this court, the person who told the court like that there was no public participation, had an obligation to prove it. Allow me to deal with the commonsensical aspect, then go to the Evidence Act. Commonsensically, my lords and your clerks in chambers will have to deal with the following question. So how do you prove a negative? How do you prove a negative if you bear that burden? But more directly, I would ask my lords to then ask your clerks to have a clear reading of Section 109 of the Evidence Act, which provides that the burden of proof as to any particular fact lies in the person who wishes the court to believe in its existence. It is actually the appellants before you who wish you to believe that there was public participation, that public participation existed. By instrument of Section 109 of the Evidence Act, the burden of proof lay on them. I trust that I have at least attempted to give guidance, as I'm professionally bound, to what this court must consider in answering those questions. My Lord, on the question of constituency creation, constituency allocation, and boundary delimitation, I would invite you to take a reading of paragraphs 442 to paragraph 657 of the judgment. When you do that, my lords, my ladies, you will discover that the court set out the history, our history of Article 89 of the Constitution on boundary delimitation. None of the appellants in their written submissions and none of the appellants in their oral submissions here have challenged specifically the historical account of the judges on Article 89 of the Constitution. It's important. Because, my lords, if Section 3 of the Supreme Court Act behoves the Supreme Court to develop rich indigenous jurisprudence, it follows that all courts beneath the Supreme Court must develop rich indigenous jurisprudence because they are bound by Supreme Court edicts. So it can't be that the Supreme Court can develop rich indigenous jurisprudence as other courts develop pedantic jurisprudence. Having said that, the judges who have taken recourse to say an understanding of Article 89 of the Constitution must be understood from our history and our context cannot be faulted. So what is that context? When you read those paragraphs, the judges tell you that constituencies now are units of resource distribution. They say that in their judgment. But judges, my lords, you live in this country, and that is a commonly notorious fact. National government, CDF, is a constituency function. Bursary funds, constituency allocated. Police recruitment, military recruitment. It's at the constituency level. And therefore, my lords, one of the greatest historical problems that this country has faced is the question of gerrymandering of constituents and their boundaries. The challenge is this, and I'm now posing the question my learned colleague Mudomithi Ankolu posed yesterday. If you interfere with the prescription by the judges of the High Court, you must ask yourself, what alternative prescription will you be proposing? Will you be proposing a prescription that allows allocation of constituencies in, to use Mr. Karori's words, political context, political way, politically, not legally, not scientifically, politically, with the net effect that you will be documented as the men and women who 100 years to come will be said to have led to skewed allocation of resources. Because once you find that the constituency now is a unit of allocation of resources, prescribing a formula that paves way for skewed distribution of constituencies, skews allocation of resources, and entrenches marginalization, contrary to the expectation of our Constitution that we have to have equity and equality, and therefore the formula to be used must be scientific. The judges therefore found that the way Article 89 is prescribed, laying out a detailed scientific formula of identifying which constituency lies where, helps in dealing with that historical problem of gerrymandering and the potential consequences of marginalization, which the appellants now ask you to entrench by judicial edict. That would be a sad day in the history of the development of our jurisprudence. So that, my lords, you will ask yourself this question: is there anything constitutionally untenable in the judges having used the text of Article 89, the history of Article 89, and the context of Article 89 to interpret it, you must ask yourself that question. I beseech you, my lords, to find there is nothing wrong with that approach that was taken by the High Court judges. There is something I want you, my lords, to reflect on very pensively when you retire in your chambers, because your work here is a little more spiritual than it is human. I mean, you are dealing with a defining case in the history of a country, a case that 200 years later, like Marbury versus Madison, people will look back long after you and I are long gone. You must ask yourself, how come the entity in whose hands the power in Article 89 is vested, the IEBC, in their appeal before you, have not challenged the finding of the High Court relating to Article 89 of the Constitution? How come? I'll go back to what learned senior John Haminwa submitted here. There must be an inevitable conclusion that they don't believe the High Court was wrong in that interpretation. They don't believe that the High Court was wrong in that interpretation. I will encourage you to find as wrong the submissions by my learned colleague, Mr. Karori, that distribution of constituencies in this country is a political question and not a legal question. It is a legal question, number one. Number two, that legal question in terms of its proximity or presence within the basic framework of the Constitution must be construed taking into account the unique history of this country. The judges did that. They looked at the Kriegler report and what it says, and to use the words of Chinua Achebe, to disown that history of this country, you must be a very dishonest person, you must be a liar, you must be fraudulent, to disown that history, because we were all here. We know how Kriegler happened. We know how it happened. To disown it, you must be irredeemably bad. Having said that, my lord, allow me in the next couple of minutes to address an issue that arose again yesterday about the continuum of this amendment process. Learned Senior Counsel, very good friend, very good mentor of mine, Senior Counsel Otiende Amolo Paul, raised the issue of severing the process of the steering committee, the task force, and something called the secretariat. He said those were three distinct processes, and that when you retire, you must make that finding. When he made that submission, I was sitting far behind in this room, and I thought the judges must have had that in mind when somewhere in this judgment, they say there's an attempt to amend this constitution by stealth. That we shall do it this way. When they ask us, we shall just say it is this way. Why do I say that, my lords? The person whom Paul Otiende Amolo wishes to convince you was the promoter of this bill, swore affidavits in the High Court, and you were taken through those affidavits in detail. I wouldn't want to do that because I don't even have the luxury of time to do that. But just a brief aspect that I would pick is to be found at page 2678 of the record of appeal filed by the Honorable, the Attorney General. So when you go to page 2678 of that record of appeal, you will find the affidavit of Dennis Waweru. That name featured yesterday, as I've said. Turning over leaf, Dennis Waweru told the High Court in a sworn affidavit that, paragraph 5, my lords, I'll not ask you to take verbatim this because it's not necessary you find the record, but for the full effect of my submission, I'll take you through it. That the building bridges to a united Kenya was created. Who created it? Was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other functions. That the Building Bridges Initiative Task Force and Secretariat, he now says they were one and the same functionaries, and Secretariat conducted a robust nationwide public engagement and collection of views on a wide array, including meeting professionals and professional bodies, among others. That upon receiving those views on various issues, it, which now refers to the Building Bridges to a United Kenya, same original entity, made various legislative, policy, and constitutional amendment proposals. Now, my Lord, we are told to ignore this that we said on oath, that this was a continuum of a process. Because when you look at this judgment that is impugned, they are saying the judges of the High Court confused this to have been a continuum of a process. That's in a nutshell what they are saying. They themselves, on a sworn affidavit, are telling those same judges that same story, that this was a continuum, one continuous process on a sworn affidavit. And that's the person you are told that is actually the promoter. My Lord, allow me to make one argument that my learned colleague, Ms. Angawa, made yesterday, and she asked me to cap it up because of the time constraint she suffered yesterday, that even if you were, and I really celebrate the young, what we call young counsel who appeared here, because they have really proved that the future of the profession is safe. I must put that on record. Even if you are to believe my learned colleagues for the IEBC, that referendum in this context is governed by the Elections Act, even if you are to believe them. I'm sure following Ms. Angawa's submissions, they may consider departing from that position. But even if you are to believe them, you then say that the obligations in the Elections Act are such that the National Assembly, when it is faced with an issue that is supposed to go to a referendum, has an obligation to approve one or more questions. One or more questions. So that, how does the National Assembly approve one or more questions? It must consider whether it is a question worth going for a referendum. There must be a thought process applied to it. And you'll see later, as she submitted yesterday, that where there are more questions, there shall be a referendum committee for each question. For each question. That's what the statute that the IEBC is calling upon you to follow says. It follows, therefore, that if the Parliament, for example, has to apply its mind to the question before it, the issue that somebody has to keep running to court to get an interpretation every time, then going to consider whether is it not, cannot arise. My Lords, I will submit to you that Parliament, for example, the Speaker of the National Assembly by law is prohibited from allowing debate on a motion that is unconstitutional, by law. The Speaker cannot allow debate on a motion that is unconstitutional. It behoves me that you have not seen speakers coming to courts to ask you, is this motion constitutional, my lords, before they go back to Parliament to conduct debates. It means, therefore, that there is an element of scaremongering in telling you that you'll be overburdened, my lords, that people will have to come here. Truth of the matter is that every person who intends to amend this constitution has an obligation to apply his own mind on whether the amendment he proposes affects the basic structure or not. To apply his or her mind. Once he applies his or her mind, he proceeds accordingly. If a vigilant citizen takes the view that the manner in which that person has applied his or her mind is wrong, it is that person who approaches to court to challenge the process, as has happened here. Courts will sometimes agree with such litigants. Court will sometimes disagree. So the argument that the judges here created a scenario where whoever wishes to amend the Constitution must come to court does not pass muster. And I will submit to you by way of comparative reasoning that this applies in all spheres of our operations. I know for a fact that if I engage in a fraudulent land transaction, that land transaction will be nullified by the court. But that does not mean that people come to court to seek an interpretation first. Is this fraudulent or not before they engage in land transaction? They apply their mind to the question, to the principles first, then begin the process. It is whoever believes the process is fraudulent that comes to court. Allow me at this juncture, in our spirit of sharing time, to invite my learned colleague, Mr. Ogada, to pick over from there and do duty for the respective respondents. And thank you so much, my lords, for the opportunity.
Thank you.
Good morning, your lordships, your ladyships. I must start by paying homage to my seniors, ladies and gentlemen who have toiled and did service to the profession, though we sit on opposite sides. Particularly have to recognize the efforts and input of Senior Counsel George Oraro, decent gentleman in every sense of the word, Senior Counsel James Orengo, Gatonye, Martha Karua, all protocols observed, Alicia Ngoya, you have done well for us and you have blazed the trail for us. In the spirit of recognition, I have to recognize my teacher, Professor Ben Murumbi Sihanya, who sits on the other side representing the Building Bridges Initiative and the Honorable Raila Odinga. And I will recall Professor Sihanya for not only being a great teacher, but also for the manner in which he dispatched me to the world of the profession and into the world of work. This is what Professor Sihanya told me and my colleagues, ushering us into the world. Go ye, people of Jerusalem, as he called us, and speak the constitutional truth. Speak truth to power. Professor Sihanya, I can assure you that I am here to speak the truth, and I'll speak the constitutional truth to the following questions relating to boundary delimitation and review. The appellants have raised certain questions with regards to the decision of the High Court. And certain issues have been raised with regards to the people and sovereignty. Certain issues have been raised with regards to the authority of the High Court. And most particularly, there have been raised concerns with regards to public participation. Judge President Musinga, you posed a question yesterday. Who are the people? I will attempt to proffer an answer. The people as a constitutional construct, and indeed the term the people is a continuous theme under the Constitution. Where do we find the term the people under the Constitution? The preamble, paragraph 2, Article 1 of the Constitution, Article 94(1), Article 129, Subarticle 1, Article 159, Subarticle 1. That is not an exhaustive list, but those are the salient examples. Now, the term the people was bandied by the appellants to show that the court, the High Court that is, usurped a power belonging to the people. In doing that, the High Court was faulted for ignoring the popular initiative, an initiative of the people, under Article 257. And in any case, the High Court was faulted for stopping the people from accepting or rejecting the Constitutional Amendment Bill at a referendum. In examining the concept of the people, and we refer to the people at paragraph 2 of the preamble, Article 1, Article 94.1, 129.1, 159.1, we submit as follows: that the Constitution knows of a distinct and graduated schema of the term the people and or authority exercised by and on behalf of the people. We want to make reference to the following. Volume 7 of the Attorney General's list of authorities in appeal, at page 2645, contains the submissions of the respondents, Justice Juma and Isaac Ogola, in the High Court. And specifically, I want the court to examine paragraph 21 of the main text, which is referenced in the footnote at paragraph 30 of the same page, a text entitled Yaniv Rosnai Amendment Power, Constituent Power, and Popular Sovereignty, Linking and Amendability and Amendment Procedures. This is in the edited text by Richard Albert, Zenon Contrades, and Alcamen Fatidu. That was by the respondents here, the petitioners in the High Court. That argument was so persuasive that the Attorney General decided to adopt it in appeal. And the Attorney General, at paragraph 44 of their submissions, adopts the graduated power scheme in the Constitution. What is this? What did the Attorney General say at paragraph 24? For quick reference.
24 or 44?
44. It is the Attorney General's further submission, they said, that the people of Kenya, in the exercise of their secondary constituent power, are at liberty to amend the Constitution without resorting to the primary constituent power and provide changes, provided that changes are done in accordance with the provisions of Chapter 16 of the Constitution. What are the distinct and graduated schema the term the people denotes under our constitutional scheme? Primary constituent power. Paragraph 2 of the preamble. The primary constituent power is not bound by constitutional rules. It exists outside the constitutional rules. It acts only when enacting a new constitution. B, the people in the secondary constituent sense. The people acting to amend the Constitution. The people acting in the course of an amendment process. Those are the people in the secondary constituent sense. Then we have a third tier, that is the constituted constitutional organs, where the people can be involved in terms of influencing decisions. So we have constituted organs as a place where the people can exercise their sovereignty. Constituted organs include the judiciary, the executive, and of course, the legislature. Now, we have to make a connection between the people and the concept of sovereignty. Due to the urgency of time, the term sovereignty is understood as residing in the people exclusively. What is understood by sovereignty? Sovereignty manifests majorly in two forms. I want to refer to you in paragraph 2, in page 296 of the respondents' bundle of authorities, page 296, paragraph 24. There's an article there by Dieter Grimm, whereby sovereignty, first and foremost, is political rule. Supremacy, political rule. Sovereignty also can denote legal power. That is in the same book, paragraph 30. The power to create and implement a peaceful order. A peaceful order such as the Constitution. Having examined the concepts of the people and sovereignty, the key question is this: what is the significance of this term the appellants have put so much emphasis on, the referendum? We submit this, that the referendum is a tool of involving the people to affirm a decision or to influence a decision. It is in democratic theory called a mechanism for direct democracy. It affirms a process. The referendum, when used in the context of making a constitution, it will be exercised in the primary constituent power. However, a referendum exercised in the process of amending the constitution, such as in our case today, within this litigation, is going to be exercised within the secondary constituent power. That distinction is important for this, that whereas the court did not and cannot have authority to examine the primary power because it exists outside it, the referendum, questions relating to the referendum, exercised in the secondary constituent sense, are examinable by the court. Quickly, we then move to how the sovereignty, the concept of sovereignty, reveals in the Constitution. And we have provided two articles, Dietmar Green and Daniel Lee, in our bundle of authorities. Dietmar Green explains sovereignty, political rule, legal rule. Daniel Lee explains sovereignty as popular sovereignty. Popular sovereignty means this, that sovereignty in the practical sense is channeled through constitution, through constituted organs. So sovereignty can be channeled through the judiciary, the executive, parliament, and there is bona fide power exercised for the people. So when the judiciary exercises sovereignty delegated to it by the people, it acts bona fide. And the same is true for the IBC, that at Article 249, one is expected to express sovereignty on behalf of the people. And let this message be clear out there, that the IBC is an independent, bona fide recipient of the sovereign power of the people, and only responds to the people, and acts in authority as granted by the Constitution to nobody else. Quickly, I move to the authority of the court. There's a growing habit in this country. Senior Counsel James Orengo made an allegory of Jezebel. Jezebels in this country have had the habit of every time judicial officers make judicial decisions in accordance with the Constitution, the Jezebels will go call judicial officers' names, deprecate their image, all in the name and in the belief that the judiciary is a lesser branch of government, that the elected branches purportedly have higher status than the judiciary. What is the authority of the High Court and indeed the judiciary under the Constitution? We have established already that the judiciary is a direct beneficiary of sovereign authority. That is not controvertible. The Constitution enables the court to be a situation, a site for sovereignty of the people. Chapter 10, Article 159(1) employs the term vests. This term vests was only used in the Constitution in reference to the judiciary and to the legislature at Article 94(1). Ask yourself, when it comes to the executive, the term vest is not used. What is the message that the drafters of the Constitution were sending to us. And what does the term vest mean? The term vests under the Black's Law Dictionary refers to this: conferring ownership, to invest in a person, full title or property. It can also mean an immediate fixed right. So, ladies and gentlemen, the Honorable Court, the judiciary is vested with property. You are agents of the people, and you have to speak the constitutional truth without fear, favor, or feeling intimidated. You are bona fide claimants of sovereign authority. The High Court, as structured in the Constitution, loosely adopts what is called the Kelsenian Court in conceptual theory. Professor Githu Muigai submitted here that the High Court engaged in lofty theory. Theory in constitutional law is part of the footstools, the African stool. Theory is one of the footstools that anchors the law. The law is anchored on the who, the what, the why. The who, substantive law. The what, substantive law. The why, theoretical law. The how, procedural law. So theory. The Constitutional Court, Kelsenian Court as it is commonly called, is a product of histories around the world. The Kelsenian Court, such as our loose model in Kenya, is equipped with a special unique power, the power of judicial review. And that power is ably pronounced at Article 165(3). And that is the authority that the court claimed when it examined the substantive values of the Constitution in the impugned bill and the procedural steps. Because the court is empowered to examine substantive questions, the value questions, and the procedural steps, the procedural values of the Constitution. And Article 165(3)(d)(2), I hope I'm correct, any threat to the Constitution is enough to invoke the authority of the Kelsenian Court, as the High Court did, in drawing from the sovereign authority it receives from the people. The High Court exercised bona fide authority. That is the authority granted to it under the Constitution. And therefore, it is demeaning, it is a tad arrogant to cast aspersion on judicial offices, to demean the image and integrity of courts for specifically doing what is decreed and declared in the Constitution. We submit a Kelsenian Court, the High Court, enjoying the Kelsenian prominence loosely as it is in the Constitution, is a bona fide recipient of sovereign authority from the people of Kenya. Quickly, I move to public participation in the context of constituency and boundary delimitation. We have provided material in our bundle of authorities at page 428 to 429, and this is a scholarly article by Professor Tina Nabachi and Matt Liniger, Public Participation for the 21st Century. A lot has been said about public participation, but this was not said. Public participation enjoys its pride of place at Article 10. And Article 10 deals with principles and/or values of the Constitution. Now, what is public participation? This is our submission, that public participation is a differentiated power track. What do I mean by a differentiated power track? It is authority belonging to the people, sui generis, and must be exercised in its quantitative and qualitative sense, and that is without apology. Public participation
simply denotes that the people, in their sovereign superiority, must influence, must have input in important matters of their governance. Public participation in the context of constituency boundary delimitation ought to have led to the question with regards to Article 89.1. Do we keep the constituencies at 290 or do we reduce them? We are burdened by loans taken from all over. The burden is too much for us. Can we reduce the number of constituencies? That is a question that the people of Kenya should have borne, if the question was posed to them. The people of Kenya, in their madness or cleverness, could also have decided to increase the number to 400. That question was not posed to them. And we have submitted that public participation in the context of boundary review and delimitation did not happen. Telepathically, I can hear a question that he who proves, he who alleges must prove. My senior Elisha Ngoya addressed the commonsensical and the legal bits of it through the Election Act. I want to answer it in the political sense and drawing from authority from this court. In the political sense, being that we are citizens and not subjects. The citizens of Kenya, Nafula from Trans Nzoia, Mwekali from Machakos, Auma from Uyomararieda, Wajiko from Nyeri, ought to have been asked about whether they want to increase or decrease the constituencies under Article 89.1. So we allege that did not happen. Now, to those who will tell us that since we are alleging we have to prove that public participation did not happen, allow me to refer you to an authority of this court, Civil Appeal number 6 of 2018, the case of Kesi Jindwa Karuku versus Steelmakers. This court said that a negative inference such as we are making cannot be on us to prove. It is for those we are citing that negative inference to certify this court that indeed public participation did happen. It did not. As I wind up, and in conclusion, one Kenyan who unfortunately demised, and Kenyans quite clearly remember him, the late senator for Homa Bay, one Gerald Otieno Kajwang, contributing to the Bomas Devolution Committee, said this: "We are the people. We must disperse power. We must share resources. We have to spread power horizontally and vertically." Quite animated as he was, that is the message of this constitution. Power has to be deconcentrated from the center. The people have to have their share of power as they envisaged under the constitution. Public participation being one track of authority as we declared and decreed unto ourselves. Another Gabriel, and this is Gabriel de Riquetti Comte de Mirabeau. This is a French legislator in the context of the ousting of King Louis XVI, a despot par excellence during the French Revolution. Told this to the military guards who were sent to come and disrupt the Constituent Assembly. I will say it in French and I will translate it in English. Allez dire au roi que nous sommes ici par la volonté du peuple et que nous n'en sortirons que la force du baïonnette. For those who don't understand French, basically, what Gabriel de Riquetti, Comte de Mirabeau, said is this: that go tell your master, your king, that we are here by the will of the people and we will only be forced out by the force of the bayonet. That's an exhortation for this honorable court. Mudomi Thiankolu, addressing you yesterday, told you not to drop the sword. When that sword was dropped, we had the radical surgery, where judicial officers were treated inhumanely and demeaned for extraneous reasons. The tenure of the judges was removed for extraneous reasons. The Constitution was reduced to blanket piece of papers. Gazeti tu ya kusoma. That is what we hear them say. This Constitution represents the solemn will of the people of Kenya. This Constitution was inked in blood. This is a product of a constitutional moment. 2007, when people died, killed, mercilessly butchered. That led to this Constitution being and coming into life. It cannot be, as has been suggested from other quarters, that this is an elite pact. Hell no. This is a product of blood and sweat of ordinary Kenyans. I end by saying this to the Honorable Court, and in echoing the words of a very noble son of Africa, Deputy Chief Justice Emeritus of South Africa, an admirable man, Digang Moseneke, the courage of principle. You have to have courage. The principle is in this Constitution. Take fortitude in what it says. Courage, principle, adherence to our constitutional pre-commitments. Those are the only saving lines for us not to drop the sword. The insults will come, the calumny will come, the indignity will come. But to you and for the people of Kenya, it behoves you to do one and one only thing: pre-commitment to the Constitution, and that alone will suffice. I submit. Thank you.
Thank you, Counsel. Who's next?
May it please the court. My name is Kevin Doho Masharia. I appear with Edgar Busiega for the...
Is it Kevin Macharia?
Yes, Kevin Doho Masharia. I appear with Edgar Busiega for the Kenya National Union of Nurses. Our petition in the lower court was petition number 397.
Sorry, you say you appear together with Mr. Busiega?
Yes, Edgar Busiega.
And remember, we're given 15 minutes. Thank you. Thank you.
Yes, I'll try.
Thank you.
Because of the little time, the 15 minutes, I'll just highlight the documents,
yes.
And Mr. Busiega will highlight the cross-appeal and the issues arising out of the betrayal of the legitimate expectation of healthcare workers. We filed a notice of address and a notice of cross-appeal.
Counsel, can you try and raise your voice, please?
Yes. We filed a notice of address and a notice of cross-appeal dated 8th June 2021. We then filed submissions dated 9th June 2021, a list and digest of authorities dated 27th June 2021, plus additions in volumes A, B, and C. Then we relied on the petition and submissions from the lower court found on the BBI record from pages 1257 to 1353, and our issues in the lower court judgment were addressed from paragraphs 620 to paragraphs 632. We had annexures which are found on volume 3, paragraphs, page 1313 of the BBI record of appeal, and the gazette notices at volume 4 of the BBI record of appeal at between pages 1574 and 1576. The position of our client is we oppose the BBI bill only as far as it excluded the Independent Health Commission as found to be found as a constitutional amendment. I'll give a few comments before I sit down. On the basic structure, we submit that the Constitution does not contemplate eternity clauses. We rely on an authority called Dead Hand Constitutionalism, Honduras, and the danger.
Counsel,
Yes.
let me understand you. You are, other than for the part where
Yes.
the learned judges did not agree that you ought to have been included in the amendments.
Yes.
In actual fact, you are actually opposed. No, you are supporting the appeals.
Yes, somehow.
What do you mean somehow?
Because when we want that health commission,
Just a
the
moment.
Constitution must be amended to include the interests of
I'm
the
looking at your
healthcare
prayers.
workers. Yes.
Your prayers are at page 2 of your notice of cross appeal, and you're saying that you want the judgment delivered on 13th to be set aside, the entire judgment be set aside, and
The petition to be allowed.
your petition be allowed.
Yes. That's as far as we go.
So you
That's
want
as
it-
far as our submissions go.
So you are supporting the appeals.
We are sui generis litigants. We only have one issue to prosecute and find a way to find the interests of our clients provided for.
So perhaps don't go into the basic structure and such other things. Just go straight to your issue of that you should have been included.
We have to, because if basic structure applies, our client will not have a way to get what they want.
Oh, okay.
Yes.
Sorry, how does then basic structure have to do with what Kenya National Union of Nurses want?
What we say-
You have one singular issue.
Yeah. What we say is this: the Constitution is amendable, and it can take into account the healthcare issues, especially the interests of our client. Because of the shortness of time, my colleague will deal with those issues. Yes, Mr. Busiaga.
Of course, it's too late now. Ideally, you should have come earlier to support this whole business of the appeal. That there should be-
He'll deal with those issues, especially on that issue.
Just a moment, Counsel.
Yes.
That you should have come earlier. It's more sense for us, in terms of where our head is, what we are focusing on now. But
Yes.
I guess it's your time.
Okay. From that aspect of what you're asking, we adopt our submissions and we ask that you give them credence to our prayers. And because of time, I just promised my colleague that I'll take 3 minutes. My 3 minutes are up. I rest.
Thank you, Your Lordships. My name is Edgar Busiaga, for the record. In the interest of time, I'll submit without necessarily referring to documents. Perhaps for the bench to understand the issue at hand and the position of the Kenya National Union of Nurses is that the Constitutional Amendment Bill of 2020 is opposed. Your Lordships, it is opposed to the extent that the nurses were not made part of the process. And what was choreographed as a public exercise in terms of seeking public views, in which the nurses presented their proposal, that proposal was ignored. Your Lordship, it was admitted in the first report, which is popularly known as the BBI report 2019. But subsequently, when the amendment bill came through, it was not part of it. To that extent, therefore, we oppose the Constitutional Amendment Bill and state that it is actually a legal fraud. a legal fraud in the sense that it does not represent the wishes of the people. My lords, the nurses were made to believe that this was a process towards uniting the whole country. And they went ahead and told people, bring your views. Now, we are being told, and that submission was made by Senior Counsel Otienda Molo, that the promoters of the bill are one Dennis Waweru and Junet Mohammed. The nurses feel cheated to the extent that the promoters of the bill, to the best of their knowledge, was the President of the Republic of Kenya. And since the nurses were willing to be part of building a country, they subjected themselves to this process. Along the way, it turned out to be a farce, not intended to achieve the will and wishes of the people, but as a vehicle to serve their own private interests. In this case, the interests of the President of the Republic of Kenya and his erstwhile foe and now friend and brother, Honorable Raila Amolo Odinga. To that extent, we oppose the Constitution Amendment Bill. If the process had been initiated with the inclusion of the Health Service Commission, an independent health service commission, with the same status, such as the Judicial Service Commission, the Teacher Service Commission, the nurses would have thought about it. The eminent submissions I've had is that the appellants want the reggae to stop from where it was paused by the High Court. We cannot allow that. We cannot be taken for a ride. The Constitution Amendment Bill does not represent the wishes of the people. Now, I'll address the element of legitimate expectation as argued in our documents. Your Lordships, the cornerstone of legitimate expectation arises from a considered assurance. In this manner, nurses, bring your views, we look at them. We presented a memorandum for an independent health service commission. In essence, it was to cater for the human resource element and to liberate the healthcare workers from the arms of the governors, the county government. We have seen the turmoil in the health sector in this country. So we had subjected ourselves to this process to the extent that let's build this country together by reducing the numerous strikes. Let the nurses, let the healthcare workers manage themselves in terms of the human resource element. Let them take charge of their recruitment, disciplinary issues, and etc. Now, this proposal was considered and indeed brought out in the first BBI report. To that extent, it is our submission that constituted a promise. A promise upon which the nurses had a belief that there will be an independent health service commission. That promise could only be taken away through a procedural process. And the procedural process here is captured under Article 47 of the Constitution of Kenya. The nurses were entitled to be heard to be subjected to a process of being heard and being given reasons why their document, their proposal had been omitted. The reasons given were that there were opposing views. Where these opposing views, they were never attached. Section 112 of the Evidence Act captures this position. They had the responsibility to bring this evidence. There are no opposing views, and therefore, this whole process was all meant to mislead the healthcare workers. To that end, I seek your findings that the Constitution Amendment Bill 2020, as approved, passed through the assemblies and the two houses, is unconstitutional. And if this court will be minded at the end of it all, and that we leave it to your discretion, to find that the process is legal, then the healthcare workers must be included as part of it. That is our submission, unless there's any question from the bench.
I don't think there is. Thank you very much.
Thank you.
Can we move to no, yes. I think he has already said I would have done this. Thank you. Thank you, Mr. Busiega, for using your time well. Mr. Chair Dudley, you have 30 minutes.
Thank you, my Lord. My Lord, I draw your attention to our grounds of affirmation of 9th of June, our submissions of 23rd of June, our submissions replying to the county assemblies on the question of popular initiative of 26th of June, and to volume 1 and 2 of our case digest of the 28th of June. We filed also one supplementary case list on the 29th of June and one bundle of undated authority replying to the views of amicus on the 30th of June. My Lord, for the appellants to win, the court must do 4 things. 1, adopt textualism as a method of interpreting the Constitution and answering the issues in this appeal. Basically, the appellants are telling the court that as long as you follow Article 255 to 257, you can invade, deconstitute, replace, and alter any part of the Constitution without reference to the primary constituent power. Secondly, the court must elevate political elites above the people, which people hold the constituent power, and only they can make or unmake the Constitution. I say that because, my Lord, the Attorney General and BBI tell you that the Constitution was made by political elites, and they do that relying on the 2008 Act. That Act, from its long object, was to complete the process of making of the Constitution. It didn't start there. It started with the 1997 Act, the Constitution of Kenya Review Act of 1997, which we've supplied, my Lord, in our supplementary case list. I request the court to turn to that act and to look at its long title, my Lord, which was an act of parliament to facilitate the comprehensive review of the Constitution by the people of Kenya and its eventual alteration by parliament. My Lord, that act, far back in 1997, recognized the constituent power. How then can we unknow what we knew in 1997? That only the people can make fundamental changes to the Constitution. My Lord, you are told that no Constituent Assembly was formed. But if you look at Section 2B of that Act, you find the Constituent Assemblies. 2002, they were formed at the district level, and there was the Bomas Conference, which happened. So, my Lord, for the appellants to win, you must ignore that history, that the people were at the center of the process of making the Constitution and exercising their constituent power. And if you look at the guiding principles in that act, my Lord, they were again consistent with the people's constituent power, saying that it was meant to provide the people of Kenya with an opportunity to actively, freely, and meaningfully participate in generating and debating proposals, this is important, to alter the Constitution. Constituent power, Constitution-making power, the original power, not the derivative power, which reposes in 255 and 257. Well, the third thing you must do, and this is the last, is to upset a settled theory in comparative constitutional law, the theory of constitutional change. That theory, my Lord, in a word, is to the extent that the power to amend the Constitution is not the power to annihilate it. And my Lord, before I come to the bulk of that, the Attorney General accepts Yaniv to be an authority. Senior Counsel George Oraro told you so. Then when the court asked Senior Counsel about the familiarity between India and Kenya, that was Justice Musinga, if I remember, Senior Counsel's response was, there's no similarity. Yaniv, at page 42, records the answer to be as follows, that India was faced with far-reaching attempts by Prime Minister Indira Gandhi to amend its constitution. We have before you 78 missiles directed at the heart of our constitution. Yaniv, page 42. That is the context in which the Indian courts applied the basic structure doctrine. And my Lord, the Indian court was not even the founder of that doctrine. They applied what Carl Schmitt had long spoken about. My Lord, in his book on the theory of the Constitution, which we've supplied to the court, you'll find Schmitt saying that the Constitution does not make itself. It is made by a higher power. That is the constituent power. And that is at page 559 of volume 2 of our record of appeal. Then he also says, my Lord, that changing the Constitution is not a normal state function, like establishing statutes, conducting trials, or undertaking administrative tasks. It is an extraordinary authority. It is an authority that belongs to the people. Senior Counsel James Orengo, who inspired many of us, including myself, to the law, left me confused. he posed the question, can the people exist outside the Constitution? The answer is yes. The people make the Constitution. Exercising their sovereign power and sitting as a constituent assembly, yes, they can alter the Constitution. They can change this country into a monarchy. And they can reorganize our modes of government. My Lord, Schmidt tells us on page 559, the last paragraph, that the authority to make amendments, I quote, contains only the authority to undertake changes, additions, extensions, deletions, etc., and that it is not the authority to annihilate the Constitution. In other words, you cannot use that power to make a new Constitution. And so that I move from Schmidt to someone else, my Lord, if you look at page 545 of volume 2 of our case digest, you will find Schmidt telling us that a constitutional law is the enabling legislation of the constitution-making will, and that it contains in it all that you need, so that if additional individual norms are written into the Constitution, that only has a technical, juristic meaning. The constituent power does not have to be written into the text of the Constitution. And that disabuses the views of Fombard, who tells you that because Article 255 and 257 do not contain the words Constituent Assembly or Basic Structure Doctrine, they cannot be invoked by the court. My Lord, did Kenyans intend that this constitution, like the current one, could be replaced, abrogated, altered gradually by amendment? I urge you, my Lord, to look at your screens for a moment and let us see also why the High Court's finding that the inquiry is factual makes sense. Kindly show us amendment number 7. My Lord, this is from page 1150 of the Attorney General's Record of Appeal, volume 3.
Sorry, we may not be able to read it from here, but
Sorry,
are you able to just
That's okay.
refer to where it is
Very
from,
well.
so that we can follow?
That's okay, my Lord.
Which volume?
Volume 3
Volume 3
of the Attorney General's
Okay.
Record of Appeal,
Which is Record of Appeal.
page 1150. If it could be turned over to the court, I would be grateful. My Lord.
Can you have the volume? Yes, continue as they get it.
Thank you, my Lord. My Lord, amendment number 7, for example, of Kenya's constitution gave the president the power to order detention without trial, to prohibit any meeting, procession of society, to impose censorship, to impose curfews, and to draft anyone into the disciplined forces, including the NYS. That amendment touched the basic structure of the Constitution. It did. The second amendment, which turned Kenya from having a prime minister to a president, also went to the basic structure of the Constitution. And the one which deleted the counties, then we call them regions, also touched the basic structure of the Constitution.
Talking of number 7.
Amendment number 7, my Lord.
Just refer to the numbers in the interest of time.
Thank you, my Lord. My Lord, there's also amendment number 14, which made Kiswahili the only language in the National Assembly. That's an amendment because it is consistent with the body of the Constitution. It does not make fundamental changes. And moving forward, if you move to the further pages, my lord, you'll find some of the attempts to amend the current Constitution. And you find proposals, for example, to deny the High Court jurisdiction over questions pending in Parliament. An amendment touching on the High Court's jurisdiction is an amendment touching on the basic structure. And so, my lord, this inquiry must be factual. You must wait for the amendment to come before you, look at it, look at the body of the Constitution, its language, and decide if or not that amendment affects the body, affects the basic structure. There is an argument that the counsel who preceded me has made about the dead hand claim, that by imposing strict rules on constitutional amendment, we'll be tying the hands of future generations. That is not a new argument. It's an argument that Fombard also makes, my lord. The answer to that argument is found at page 4 to 5 of Yaniv Rosnai. In justifying the amendment rules, he looks at both sides. Yes, the Constitution must be flexible, but it is not amended the same way as a statute, a fact that Parliament knows. And that is why the Interpretation and General Provisions Act does not apply to the Constitution. The Act recognizes its own insufficiency. It tells you, don't look at us when it comes to constitutional interpretation questions, including amendment. And my lord, the Constitution cannot provide for its own repeal. No Constitution provides for its own death. And so special rules apply. Hans Kelsen, which you will find quoted at page 39 to 40 of Richard Albert's book, which is the supplementary authority we supplied to you in response to the amici, tells us that because the Constitution is the grand norm, it's at the base of the national legal order, it is desirable to give it a more stable character. And so, my lord, special rules apply to the amendment of the Constitution. These rules can be written, like in Article 255 to 257. They can also be implicit, discoverable by reading the Constitution holistically. My lord, if it were not so, can we say that if you get the numbers and follow the procedure in 255 to 257, you can come one day and delete the judiciary or deny it its independence? It has happened before. I do not speak in the abstract. Can we say that as long as you get the numbers, 1 million signatures, get people who are sufficiently angry with the counties, you can come and delete the chapter on devolution? It has happened before. Can we say that as long as you follow 255 to 257, you can come and kill the Senate? It has happened before. All the amendments, each one of them, that killed Kenya's constitution followed the procedure. Each one of them. In fact, at times, the threshold was lowered to make it easy for amendments to pass. Some passed in a single afternoon. My lord, imagine being detained without trial because the Constitution has ordered it. Where does one turn to? And so the Constitution must have a higher place than ordinary legislation. The mistake that my my friend Mr. Paul Mondi makes is focusing on India as the origin of this doctrine. My lord, while they see, I quote, a doctrine of a highly doubtful origin, rejected, again, I quote, by a vast majority of scholars, a vast majority of courts, and which is repudiated by an overwhelming number of scholars, Yaniv Rosnai sees a growing trend towards adopting this doctrine. That is Yaniv at page 70. And Richard Albert, another authority in this area, whose work you will find in our authority replying to Amisi submissions, also sees the same trend. Richard Albert, you'll find it in volume 1. Sorry, you'll find that in Richard Albert's book, where this has gone to Belize and the Czech Republic, Latin America, my lord, Asia, Africa. It's no longer an Indian doctrine. It never was to begin with. Carl Schmitt was not even Indian anyway. And Paul Mwangi cited to you Professor Upendra Baxi as dissuading you against applying this doctrine. I wish he cited to you what Upendra has recently said about this judgment, David Lee, in his article, Hooks, Pillars and Foundations. He finds that it's a legitimate doctrine and the Kenyan High Court placed the people at the center of the Constitution, unlike Senior Counsel James Orengo. My lord, that doctrine is so theoretically sound that the the Kenyan judiciary has already held that the basic structure doctrine binds it in interpreting the Constitution. You find that at the CCK case, para 362, where the Supreme Court says, and I quote, "The Kenyan Constitution sets to the judiciary, my lords, its barricade against destruction of its values and weakening of its institutions by forces external to itself." Also look at the Martha Kerubo case, which supplies the various names to these doctrines. My lord, even if the appellants block you from applying what they're calling the basic structure doctrine, what about the Colombian constitutional replacement doctrine, which applies to the same theory, the theory of constitutional change? The power to amend is not the power to repeal or to destroy. My lord, at page 215 of Yaniv, you'll find Yaniv saying that the Constitution's language is not just the explicit language, it's also contextual, because the Constitution has a history. And that's something the Supreme Court explains in Speaker of the Senate. It says that the Constitution is a document of compromise, Speaker of the Senate, para 156, and so that compromise facilitates ambiguities, vagueness, and gaps in physiology. But constitution making does not end at promulgation. It continues with interpretation. And so you have the chance before you to make or unmake the Constitution. My lord, to allow the appellants to win, you'd also have to disregard all modern constitutional law comparativists. Paul Genyap, we've supplied you with her work. Hannah Lena, David Landau, Rosalind Dixon, Mark Tashnet, all modern comparativists, because their work support the High Court judgment. I move briefly, my lord, to the question of presidential immunity. And my lord, the president does not enjoy absolute immunity. If he did, for example, under Article 143.3, the president can be sued after he leaves office. It freezes time from running, 143.3. What sense would it make to sue the president after he leaves office for official acts? Why would we bother a retiree after he leaves office? And so in short, Article 143.3 must be interpreted holistically, that's one, as the High Court has done recently in Katiba Institute, a case I was privileged to argue against Senior Counsel Waweru Gatonye. The president on being sued for failing to appoint the 41 judges, raised a preliminary objection urging his absolute immunity from all processes. The High Court overshot that. We ask you also to do the same. Number two, there's no single president that from any country in the world that gives the president absolute immunity. President's Counsel could only rely on Nixon versus Fitzgerald, but Nixon versus Fitzgerald had different facts. It was a claim for damages for unfair termination. It was not a public law claim like the one before you. So it does not support, it helps us. And if you look at it, my lord, you'll find phrases like private lawsuits, damages, liability for damages. It prevents private lawsuits. And the reason in Kenya is because of 165. Anything done or said to be done under the Constitution falls within the jurisdiction of the High Court. My lord, lastly, as I yield the floor to my learned friend, Mr. Ian Madenge, is that presidents have routinely been sued around the world for public wrongs. President Trump 2 years ago, President Jacob Zuma, recently sentenced to contempt. And my lord, if anything, and I say this with a lot of respect, the current president has shown us why a president must not have absolute immunity from all proceedings, especially those ones touching on the Constitution. My lord, I rest my submissions and request you to call my colleague, Mr. Ian Madenge, to the podium. Thank you, my lord.
Thank you, Mr. Chair. 10 minutes, Mr. Madenge.
Yes, ma'am. Good afternoon, my lords.
Good afternoon, Mr. Madenge.
Let me start from where my colleague has left by assisting the court on two issues. The first issue, my lord, is whether the text of the Constitution supports basic structure. And I will be making two arguments, my lord. The first argument is that the text of the Constitution indeed supports the basic structure. And to illustrate this, that the Constitution has a core content. There's no Constitution without a core content. Number two, my lord, is that the Constitution has foundational and prior principles. And I will demonstrate it to you, my lord, and my lady.
Foundational
and prior principles.
Okay.
What we call immutable principles in constitutional law.
Yes.
To demonstrate that, my lord, is Article 4.1 of the Constitution. 4.1 indicates that Kenya is a sovereign republic. It just declares the state of Kenya. It does not in any way grant Kenya sovereignty. That can be contrasted, my lord, with Article 156.1, which establishes the Attorney General. Number two, my lord, even more important and revealing is Article 4.2. It provides that Kenya is a multi-party republic founded on national value. So the foundation of Kenya and the Constitution is indicated in Article 4.2. That is what we call the value system of the country. You find it there. If you change that, you are replacing the Constitution. That is the value system expressly provided. And one claim, my lord, that I think will not be controverted is inherent nature of human rights. You find it in Article 19.1 and 19.3. Inherent nature. It indicates that that is prior. It is immutable. The Constitution does not grant it. It cannot change that. I will not go on, my lord, to discuss what was discussed on the issue of Kasevananda, but there is a misrepresentation. The High Court did not follow Kasevananda, line, hook, and sinker. It adopted it to our situation. Kasevananda said you cannot amend. The High Court says you can amend using the 4 steps which call in the constituent power. I'll rest that point there and move to the second point, which is even more important, my lord. The second point, my lord, you are told that the president is the one who promoted the popular initiative. I will not delve into that. The question that I'll seek to answer, can the president promote? And to answer that question, my lord, I'll refer you to authority number 78. Authority number 78, that is volume 2, page 677 and 673. It defines what is popular initiative. We provide an authoritative definition of popular initiative in 673 to mean the rights of the people, and the key word in both is the people, my lord.
You say page 677.
677 and 673. 677 is paragraph 4. My lord, then that takes me to my 3 arguments why the president cannot initiate popular initiative. The first one, my lord, and I hope I'm not too fast, it's only the time that is harassing me.
Yes, proceed.
Number 1, my lord, is that the president has no power in the Constitution to initiate popular initiative. I have looked at the entire chapter 9, my lord, of the Constitution, and in particular Articles 131, 132, and 133, which provides for the powers of the president in extensive manner, and expressly so. None involves amendment of the Constitution. I contrasted it with the previous Constitution, my lord, that was repealed, and in particular section 423 and chapter 2, the president's power were very narrow. This time we provided them extensively, and none involves amendment of the Constitution. So the framers of the Constitution did not want the president to amend the Constitution. Even more important, my lord, is that Kenya, the argument number 2, Kenya adopted popular initiative as opposed to government initiative. Globally, my lord, there has emerged 2 types of initiative: government initiative and popular initiative. And we have done a comparative study of the practices. And I want to refer, my lord, you to our band of authorities, volume 2, authority number 79. This is key, my lord, to the determination of this case. Authority number 79, page 736. That is volume 2, authority number 79, page 736.
What is the authority? Please mention it.
It is Andy Amani, referenda and the citizen initiatives. Andy Amani, referenda and the citizen initiatives. And that authority, my lord, contrasts 2 types of initiatives that countries can adopt. The first one is government initiative, and it identifies 2 characteristics. And that is what you'll find also in Turkey, to give an example. Number 1, it can only be initiated by the government, either legislative or executive, my lord and my ladies. That is the first characteristic. The second characteristic, my lord, is that the government decides whether to call the referendum or not. So like Turkey, it's only the president who decides whether to call referendum or not. That can be contrasted with what we call popular initiative as described in that authority. And popular initiative has the following characteristic. Number 1, it is a people's pushed process. Number 2, it has signatures threshold of signatures. That is page 737, authority number 79. Page 737, authority number 79. That answers that question decisively, my lord and my ladies. And lastly, it has verification of the signatures. That is a key element. I don't need to say any more on that, my lord, but let me give you even the third justification, my last argument. My lord, the president being involved changes the character of democracy at play. The third argument, altering the character of democracy at play in popular initiative. Changing the character of democracy at play in popular initiative. And to understand the character of democracy at play is our authority number 78, page 677 and 676. It says that it is direct democracy which is at play. Direct democracy has a number of characteristics. Number one, it is pure form of democracy. It is an act of self-rule. It is a bottom-up democracy. Bottom-up democracy by the people. Number three, it recognizes the ultimate sovereignty of the people in Article 1. So that democracy is subverted. That is my argument, my lord. Is subverted if a representative or the executive is involved in popular initiative. It is subverted. It ceases from being direct democracy to what we call representative or indirect democracy.
Last submission.
The last submissions, my lord, is that the Constitution, and this has been said, is that the Constitution distinguishes between the people and the representative. That is Article 1, 2, the people may exercise directly or through their representative. 1, 2, my lords. And number 2, Article 255.3b. Article 255.3b says that the amendment be brought by the people and the representative, or the representative. So the representatives are not the people as per the Constitution. That is the conclusion, my lord, that the representatives are not the people. And for that reason, my lord, I was supposed to address another issue, but I think...
No, that's a good place to stop.
Yes.
That is, the representatives are not the people. Thank you very much.
Thank you, my lord, and thank you also for your kindness and giving me this time.
Thank you. Now, we are progressing fairly well. We will take a lunch break, and when we come back, we have Mr. Oluchir and Dr. Eboso. Yes, so we resume at 2:30.
This conference is no longer being recorded.